Start. The respondent bank submits that as per the provisions of law, the respondent bank proceeded to consider the representation of the petitioner and it was rejected vide order dated 13/4/2003, which was communicated to him on the same day vide Pune book. It is further submitted that the Pune book clearly reveals that the petitioner had declined to take notice of the order passed and communicated to him, and therefore no illegality has been committed in issuing the impugned auction notice. It is further submitted that the petitioner was recalcitrant borrower and has been willfully evading payment of the borrowed amount, and therefore the bank, after giving repeated notice to him, has proceeded to take recourse to and had filed the certificate case as well as proceeding under the Surfacy Act against him for recovery of public money due to the bank. It is further submitted that any objection filed by the petitioner having been rejected and communicated to him, no illegality has been committed, and therefore the writ application and the case of the petitioner is not fit to be entertained, as the impugned order is wholly in accordance with law. Having heard learned counsel for the petitioner, learned counsel for the bank, and after considering all the facts and circumstances of the case, it appears that the petitioner, after the last order was passed, had cooperated in both the proceedings. It further appears that in the certificate case, the order was passed for making the payment, which is being duly complied with by the petitioner. As submitted by the petitioner, he has already deposited a sum of rupees 5 lakh till January 2017. So far as illegality with regard to the violation of the provisions of the Surfacy Act is concerned, this court finds that the contention of the petitioner that both the proceedings cannot continue together untenable in view of catena of decisions of this court as well as the apex court. However, so far the communication of the rejection/objection order is concerned, this court finds that there has been insufficient compliance of the provisions of law as a mere entry in a Pune book without any affidavit to support such an entry by the concerned Pune would not suffice to indicate a communication of the rejection order to the petitioner. The appropriate method to have been adopted by the bank would be a communication.
Stop. ये पैसेज पटना हाईकोर्ट के लिए बहुत ही इंपॉर्टेंट पैसेज है। एग्जैक्टली 400 वर्ड 4 मिनट में बोले गए हैं। 100 WPM की स्पीड थी, जो कि पर्सनल असिस्टेंट के लिए यूज़फुल है। और इसी चैनल पे पटना हाई कोर्ट और झारखंड हाई कोर्ट से रिलेटेड वैकेंसीज़ के लिए डिक्टेशंस अपलोड किए जाएंगे, तो चैनल को सब्सक्राइब ज़रूर कर लीजिएगा और अपने दोस्तों को भी शेयर कीजिएगा जो हाई कोर्ट की तैयारी कर रहे हैं। और साथ ही हमारा टेलीग्राम ग्रुप, जिसका लिंक डिस्क्रिप्शन में है, उसे भी ज्वाइन कर लीजिए, क्योंकि सारे पैसेज और मैटर्स उसी ग्रुप पे अपलोड किए जाते हैं। थैंक यू।